Well, welcome everyone, and thank you so much for joining me. I'm Lior Samfiru, the employment lawyer. You probably already knew that, but I'm here, of course, as I am on Wednesdays live, answering your questions. This is your employment law session. So again, I'm Lior Samfiru, one of the partners, the founding partners of Samfiru Tumarkin LLP. You'll find us in Ontario, in BC, in Alberta, of course. So if you're across Canada, if you have an issue with your employment, with your rights in the workplace, you're in the right place. We all have these tremendous rights across Canada. The problem is we don't always know what those rights are. So we're here to talk about the rights you didn't even know you had. Whether it's a wrongful dismissal question, a constructive dismissal question, maybe your boss is not being reasonable, they're changing your job, put you on a temporary layoff. Maybe you're being mistreated by your boss or colleagues, what to do, what to say, what does the law say? On this session, I can tell you all those things. And it starts with you asking a question. Can't answer your question unless you ask it, right? So type it in, hit enter. I'll see it, I'll read it, and you can walk away with all the answers that you need on this session. So this is about you. Be the voice on this session. Make sure that when I turn off my computer and you turn off yours, you've had those answers. You've received those answers. Now, of course, beyond this session, beyond this is a 30-minute session. Beyond that, if you want to connect with me and my team across Canada, unbelievably easy to do that. All you do is you go to employmentlawyer.ca. Again, employmentlawyer.ca. And when you go there, you can get the phone numbers to call or the email address to use. You can fill out a form if you want. You can also read a lot more about your employment law rights. So it's your one-stop shop, employmentlawyer.ca. On this session, I can answer questions, I can tell you things, but I can't actually roll up my sleeves and help you. To get me to do that, you can need to contact myself and my team through employmentlawyer.ca. So that's what you do. But right now, I'm live. I see questions already coming in. I'm going to start answering them. But for now, you have time to think about the question, to make sure that you phrase it correctly. If you want to know about employment law, if you want to know about workplace rights, I'm here, Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, for you, with you, answering those questions. Well, we know what we need to do. Let's get to doing it right now. First question today from Susan, who is joining us from YouTube. Susan says, I emailed C-suite of a nonprofit health and safety. Okay, I'm not sure exactly what you mean. Of nonprofit health and safety and regular unpaid works. I'm not sure what you're saying there. You're saying that you were fired. You may want to rephrase that question. I'm just trying to see if I didn't understand it. Paid works for vulnerable sector employees. C-suite said they are aware. Okay, I understand. I think you're saying that you raised some health and safety issues, and you were fired. And what damages can I get? Well, first of all, if you raise health and safety issues, it's illegal to fire you. All right. What I mean by that, that's what we call a reprisal. You cannot be let go because you're raising health and safety issues. That's a breach of occupational health and safety legislation. It could be a breach of the employment standards legislation. It's illegal. So we need to talk about that. I want to know exactly what you said. I want to know how they responded, how soon after you were let go. Keep in mind, of course, that even apart from this reprisal issue, you're owed severance. And depending how long you've been there, that could be as much as 2 years' pay. So there's a lot here that we need to discuss, Susan. So what I want you to do is I want you to connect with me as soon as possible. Don't wait on this, okay? I want you to connect with me as soon as possible off this platform by email or by phone. And here's how you do that. Just go to employmentlawyer.ca right there. See that address right here? Employmentlawyer.ca. Phone numbers there, email addresses there. Because no, if you raised a health and safety issue and you were fired, completely illegal, can happen. Potentially even get your job back if you want it. Certainly there's damages owing in addition to severance. So Susan, now you know, contact me. See how easy it is? That was our first question today. You can ask yours. More have just come in. I'm going to answer them. But you have time now. Plenty of time still, at least 25 minutes or so. So ask your question with me, Lior Samfiru, the employment lawyer. All right. Next question to us comes from Facebook, and this is Jordan. How is severance calculated if you have had gaps in your pay recently due to lack of work? So if your pay goes up and down, when it comes to severance, we will simply look at an average. So not everyone makes the same amount every month, every week. So if your pay sometimes is higher, sometimes is lower, we look at an average. Depending how long you've worked with the company, we may look at the 1, 2, or 3 year average and use that. So if on average you make $10,000 a month, just as an example, we'll use that figure to calculate your severance. So the company is going to want to use the lowest number. Can't do that. We're going to look at an average because that's the only reasonable indication of what you would have earned had you stayed on. So based on that average, that's what we're going to use. And the key, of course, is to make sure that you get the right number of months of severance. Remember that when you're let go, doesn't matter if you work for a big company or a small company, chances are that whatever you've been offered is a lot less than what you're actually owed. That's true in over 90% of cases. In fact, it's extremely rare for me to review a severance package that's adequate. For me to say to someone, you know what, that's a good offer, you should accept it. No, in almost every case, when I look at a severance offer, my colleagues across Canada look at a severance offer, we shake our head and say, my gosh, what was the company thinking? That's a lot less than what you're actually owed. The good news is it can easily be resolved. We can easily get you what you're actually legally owed, but we can't help you unless you reach out. So if you lost your job, doesn't matter to me if you worked for 2 months or 20 years or any other amount. You call, you email, we do this right. And of course, to connect with me, employmentlawyer.ca. Again, employmentlawyer.ca. All right. But right now I'm live. Ask your questions. Just like Arthur, who has our next question. Arthur says, when working for an overseas company as a remote worker, what happens if you're let go? What sort of rights do you have? So that's a great question, Arthur. And the answer is that the laws of the place where you work, where you physically work, govern. So if you work in Ontario, let's say, if you're physically in Ontario, but the company is in a different country, the laws of that other country do not matter. It's the laws of Ontario in that example, the laws where you physically are located, where you physically work, that matter. That means that if you lose your job, you're going to get paid based on our laws here because that's where you're working. The company may take some time to understand that. We may have to educate them. They may think, no, we're headquartered in Germany, so it's going to be the laws of Germany. No, it's going to be the laws in Canada, where the person is actually working. And that's actually a good thing, because in Canada, we have some of the best employment laws in the world. So that's what happens. So if you're let go, doesn't matter if you work for a company that's overseas or not, you got to call me, because there's even a greater chance that whatever they've offered you is nonsense. It's not even close to being adequate. So you got to reach out to me ASAP. So Arthur, hopefully that makes sense. Very important question. I've been asked that often. You need to know that. Now you do. And everyone else, you see how easy it is to ask your question, to get an answer. More questions have come in. I'm going to answer them right now. But please do that as well. Don't wait till I'm done this session, and then you'll ask the question and there won't be anyone here to answer it. Ask it now while I'm here. Of course, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. They call me the employment lawyer because I talk employment law and I resolve employment issues. So let's continue doing just that. Oh, okay, let's see. Reggie has our next question. Reggie says, wife's employer has said that they may not have space for her to return to after finishing her maternity leave. They only mentioned this recently. What can she do about this? So first of all, for now, while she's on maternity leave, she doesn't do anything. She continues staying on maternity leave. She does what she needs to. We deal with this when she's ready to come back to work, unless, of course, they actually let her go before. But if they don't actually let her go, when she's ready to come back to work, if they do end up taking her back to the same job, no problem. If they don't, if when she's ready to come back to work, they say, sorry, we don't have a job for you, well, wait a second. That is potentially and very likely actually illegal. An employer is required to take an employee back when they come back from parental leave, if at all possible. Now, listen, if the department is shut down and everyone was let go, well, maybe then they can get away with it. But if they simply decided they don't want her job anymore, can't do that. Illegal, a breach of potentially a couple of statutes, including a human rights violation potentially. So at that point, we deal with it. Sometimes if they hear from me, they change their mind. If that's not what your wife wants, you can get compensation in addition to severance, of course. But the key is, at this point, there's nothing you need to or you can do about this. Have your wife continue her mat leave until she's ready to come back to work, and then see what happens. Obviously, in the meantime, if they formally let her go, you have your wife contact me right away. Okay, so for you and your wife to reach out to me, I've said it before, I'll give it to you again, employmentlawyer.ca. Again, employmentlawyer.ca, right there on the screen. Phone numbers there, email address there. Easy to remember, right? employmentlawyer.ca. So Reggie, that's the answer. Now you know. Make sure you have your wife connect with me if she's let go or if she's trying to come back from mat leave and they won't take her back. So hopefully that's very clear. If there's a follow-up question, Reggie, please ask it. Lots of questions coming in today. That makes me really happy. So let's continue those, guys. I will answer all of them. Just ask them. Again, I'm Lior Samfiru, the employment lawyer. Wayne has our next question. And my new employer took over my last company and then stated I needed to work different days when I've been working the same shift for the last 8 years. When I refused to due to childcare and my child with disabilities, I was told to get childcare and I could be terminated for non-compliance. So here's the thing. Forget about the childcare issue just for a second. I'll come back to it. Your employer doesn't have a right to change your day. So if you're consistently worked a particular schedule, your employer by changing that schedule, that could be a constructive dismissal. It's not non-compliance. It's your employer doing something that's illegal. So right off the bat, they don't have a right to change your schedule. But now, if you need to be home at a particular time and you can't really get childcare, well, then they have to accommodate you. That under human rights laws, they have to accommodate based on what we call family status. So if you have a child that you're caring for, and the only way you can care for them is by your employer helping you with your schedule, they have to do it. And if they don't, again, that's a human rights violation. So number one, constructive dismissal. Number two, human rights violation potentially, Wayne. So it's not legal. But what you need to do right now is you need to connect with me off air ASAP, today, ideally, okay? You do that through employmentlawyer.ca. If your main goal is to continue working the schedule that you've been working for the last 8 years, if that's what you want, a letter from me is going to do it, okay? As soon as I tell them what their obligations are, see how quickly they back off. So connect with me. Easy to do, employmentlawyer.ca. Again, employmentlawyer.ca. Okay, great question. So let's see. Next question on YouTube from GBRVDA. I don't know how that's pronounced. I'm a VP of a US-based company. We have a Canadian corporation just to pay Canadian employees. My work is about to sell our unit. If the buyer offers me lower pay, can I refuse the contract and get severance? Yes. So generally speaking, if the pay is, let's say, more than 10% lower, that would be something you don't really have to accept at this time, and that could absolutely mean you can get severance. But before you say yes or no to an offer, I want to talk to you. Okay, we don't say yes or no until I've spoken to you. We can dot our I's and cross our T's. I want to see the employment offer that they gave you. In fact, there may be other reasons why it shouldn't be accepted. So definitely review it. But yes, generally speaking, if the pay is going to be significantly different, you don't have to accept it. And then, yeah, you're absolutely going to be owed severance. But again, I want to do this right. I don't want to, we don't want to put the cart before the horse. What I mean by that is before you say yes, before you say no, before you say maybe, talk to me. Send me the offer. I want us to have a proper discussion, and then we can proceed from there. So hopefully that helps. And again, if it doesn't, if you have follow-up question, ask it. Otherwise, connect with me and my team through employmentlawyer.ca. Again, employmentlawyer.ca. All right, continuing to answer questions. Great questions coming today. By the way, if you've just joined us, my name is Lior Samfiru. I'm the employment lawyer, and I'm here on this session every week answering your employment law questions live. So I'm live right now. Hi. If you have a question, you can ask your question right now. You see that box on your screen, type it in, hit enter. I'll see it, I'll read it, and I'll answer it. Next question comes from Wilfred. Wilfred on Facebook, he asks, what do you charge to start working on a case. So most of our cases, probably about 80%, are on a contingency basis, meaning we don't charge anything and we only take a percentage of any new money we're able to get someone. In some cases, we can't offer that, but I won't know what we're able to offer until we do a proper consultation. So that's really the answer to the question. Whichever option ultimately is offered, hourly pay or contingency, one of the things we negotiate is compensation for your legal fees from the other side on top of other amounts that are owed to you. And in the vast majority of cases, we're able to do that. So Wilfred, hopefully that answers the question. Thank you again. To connect with me and my team, employmentlawyer.ca. All right, let's see, continuing to answer questions. Next one on Facebook from Peter. I was suspended from work for a few days, but I never received any sort of written warnings. I haven't been recalled back and I'm not sure what to do. What happens if they don't call me in? So everything I'm going to say right now applies to non-union employees. And by the way, everything you hear me say, period, only applies to non-union employees. If you're part of a union, there's nothing I can do. And the only one that can help you is the union. And everything you hear me say today does not apply to you. But for a non-union employee, if he's put, if Peter's put on a suspension, your employer's not allowed to suspend you without pay. If they want to keep you off work and pay you, I guess they can while they're investigating, but they're not allowed to suspend you without pay. So you now can consider this suspension as a termination of employment and get severance. It wasn't legal to begin with. Your employer does not have a right to suspend you without pay. Therefore, you can say, well, I'm going to sit at home and be a nice boy and wait. That's fine. You can do that. Or you can simply say, no, I'm not accepting this. I'm not okay with this. I'm going to consider this to be a termination of employment and get my severance. So you can do that right now, Peter. You don't have to wait. If you want to do this right now, if you don't want to wait, if you just want to get your severance and move on, connect with me as soon as possible through employmentlawyer.ca. Hopefully that makes sense. Follow-up questions, please ask them. So Reggie has a follow-up question. Reggie was asking about his wife that's on a maternity leave and may not have a job back. And Reggie says, my wife works for a not-for-profit. Does that at all change their obligations? Absolutely not. It does not. As long as she's an employee, the law determines the obligation. Doesn't matter if she works for a Fortune 500 company or for a small not-for-profit. The legal obligations to employees are the same. Certainly when it comes to coming back from maternity leave and what's legal and what's not legal in that situation, the obligations are the same, Reggie. So now you know and your wife knows. And as I said, she can reach out to me if she's let go now or coming back from maternity leave. If she doesn't have a job available to her, they don't take her back. She calls me and we will deal with it. Thank you for those questions, Reggie. Excellent questions, very important ones. By the way, before I continue answering questions, I've mentioned the word severance a bunch of times already on this session. So the next question I always get is, well, how much severance do I get? How is severance calculated? And how do I know? Well, it's very easy to do. If you want to find out at any time what is severance for you, how much you're owed, what your employer's obligations are to you, easy to do. You just grab your smartphone, your tablet, your desktop, anything with internet on it, and you go to pocketemploymentlawyer.ca. Look at that, right on the screen, pocketemploymentlawyer.ca. When you go there, of course, you'll see our severance calculator tool. The severance calculator is something I invented about, 8-9 years ago, I guess, maybe more now, used by over 2 million people across Canada. And it does what the name suggests. It tells you and it calculates how much severance you are owed. You answer a few questions, that's going to tell you if you're owed 6 months severance, 24 months severance, 18 months severance. It's free. It's anonymous. No names, no company name, no date of birth, no credit card, nothing like that. All right. It's completely there for you, free and anonymous. And when you get the answer, if you want to, and only if you want to, there's a green button at the end you can press to contact me so I can actually help you get that severance. So check it out, pocketemploymentlawyer.ca. There's other features to the Pocket Employment Lawyer, but the first thing you'll see and you'll want to use is the severance calculator, even if you haven't lost your job, but you're just curious. You just want to know, hey, what is severance for me? What would I be owed hypothetically if I lost my job? pocketemploymentlawyer.ca. Check out the severance calculator. All right, now you know. Next question. Right now I'm live. You still have a few minutes to ask your question. Take advantage. Let's get those answered. Jordan has our next question on Facebook. A lot of people on Facebook today. I love seeing that. If an employee is dismissed and the employer does not mention anything about severance, should you ask the employer immediately or should you give them a bit of time? I'm not in a situation like this. I'm just curious. So it's extremely rare for someone to be let go and not be told anything about severance. Usually it's because they have an employer that's completely clueless. Very rare. Obviously, if your employer says goodbye and nothing about severance, you ask the question. Okay, but what are the chances that an employer that has not said anything about severance actually is going to know how much severance you're owed? You ask the question, but the reality is you're not going to get anything appropriate, so you call me. Okay, and we get to work, we get you the severance that you're owed, but it's very rare. I think I've seen it a couple of times where someone is let go and the employer forgets about severance. No, they're not. What is going to happen is whatever severance they're offering is going to be silly. It's going to be half or a third or 10% of what the person is actually owed. That's what's going to happen. So hopefully that makes sense, Jordan. And any issues for you, for someone you know, connect with me through employmentlawyer.ca. All right, lots of questions today, guys. Must be something in the water. I love it. Ed has our next question again on Facebook. I've been on disability for 2 years. Now the insurance company wants to change it to permanent disability and only 60% of pay. What should I do? So your insurance policy document outlines what they have to pay you. So after 2 years, if you're still unable to work in any job, then you can continue on long-term disability, potentially till the age of 65. Now, the insurance policy says how much they're going to pay you. If it says 60%, then it's 60%. If it says 90%, but they're going to only pay you 60, well, they're in breach. Chances are that if they're saying 60%, that's because what the insurance policy says. Ask for a copy of the policy. You'll be able to get that either from your employer or your insurance company very quickly. Take a look at it. It should be obvious. If you're not sure, just send me a copy and I can tell you. But generally speaking, if your insurance company says it's 60, that means they're following the insurance policy document, the contract of insurance, which stipulates that. So hopefully that makes sense, Ed. But again, if you're not sure and you get a copy of the policy, you need help understanding it, connect with me through employmentlawyer.ca. So let's see. Glenn has a question on YouTube. By the way, last few minutes, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. You can still get a question in under the wire, so ask it right now. Glenn has our next question. When being off work on disability, can your employer let you go over I'm not sure exactly what you didn't finish that sentence. What if you're off work for 3 to 4 years? So your employer can let you go, generally speaking, if you've been off for a long time, if there's no likelihood of coming back to work. And what I mean by that is if you've been off, let's say 3 to 4 years, and your doctor's still saying, we don't foresee that you've been able to come back to work, they can let you go based on what we call frustration of contract. So that happens if you've been off a very long time, usually 2 years or more, and there's no likelihood of coming back to work. If that's the case, they can let you go, and they may only owe you a very, very small amount in that situation, because essentially what happens, the employment relationship has ended given the lengthy absence. But if you've been off for 3 years, but your doctor is still saying you may be able to come back to work at some point, they can't do that. And if they try to do that, that could be a wrongful dismissal. It can even be a human rights violation. So it all comes down to what your doctor is saying about your ability to come back to work at some point. Hopefully that makes sense. Glenn, if you have a follow-up question, connect with me, or better yet, contact me through employmentlawyer.ca. Bill has our next question on Facebook. Do you handle short-term and long-term claims? Absolutely. We have a whole team at my law firm dealing exclusively with disability insurance issues, short-term disability, long-term disability. Their job is either to get the insurance company to do what they're supposed to, or to negotiate proper compensation. So if you have an issue by all means, Bill, I want you to connect with me, and I'll connect you with my colleagues. We have a whole team just dedicated to this. So Bill, to connect with me, employmentlawyer.ca. Again, employmentlawyer.ca. All right, let's answer some more questions. Roland has our next question on YouTube. Can my employer let me go because they want to hire someone for significantly less money? The answer, unfortunately, is yes. Your employer can let you go pretty much for any reason, as long as it's not a discriminatory reason, as long as they pay you proper severance. So if they say, you know what, we can hire this person to replace you and pay you less, that may make them not nice people, but legally they can do that as long, Roland, as they pay you your full severance. Here's the thing, though. I don't know anything about you or your employer. Didn't tell me who you work for, but I can almost guarantee you that whatever they're going to offer you for severance is going to be a lot less than what you're actually owed. We can get to work if that happens, get you proper severance. So if you do lose your job because of that reason or any reason, you call me right away, and we'll make sure you get everything you're owed. Okay, Roland, so you know what to do. Employmentlawyer.ca, the way to do that. I'm going to try to take a couple more questions. I always say questions come right at the end. YYZ has our next question on YouTube. Our company moved business overseas and are laying off. I would like to get severance. In the meantime, I go overseas on family leave. Can I still get severance? Well, if your employer has approved the leave, then yes. If your employer has not approved the leave, if you leave, that's a resignation and you're not owed anything. So you can't just take off. If you ask for a leave, you need to go away, you want to go away, if that's approved, no problem. You go. If you lose your job, you're owed severance, no issue. If you just decide, well, I want to be seeing my family, so I'm going to go, but the company has not approved it, no. That's a resignation and you don't get anything. So hopefully that makes sense. If and when you lose your job, chances are, as I said, whatever you're offered is a lot less than what you're actually owed. So you have to call me immediately. Again, employmentlawyer.ca to connect with me and my team. All right, let's see if we can get a couple more questions in under the wire. Jordan, if you work on call with the company for several years, where your pay varies by year, is your severance based on average for the entire term of employment, or how is it calculated? So usually if you work there for a bunch of years, we're going to do a 2-year average or so, and use those 2 years as to for your severance. If you only work for a year, we'll just look at your year and see how much you earn. So usually it's a couple of year average, and on that basis, severance is going to be calculated. All right. Glenn has a question. Can your employer replace you while on disability and say that we have another job for you, but not sure yet what that job will be as we are restructuring? What should I do? So while you're on disability, you don't worry about it. You do what you need to get better, okay? And we deal with that when you're ready to come back to work, because who knows, by the time you're ready to come back to work, things can change 7 times. So what is true today may not be true then. When you're ready to come back to work, if your job doesn't exist anymore and there's a very different job, that could be a constructive dismissal. But for now, while you are off on disability, it doesn't matter. You don't worry about it. You only worry about that when you're ready to come back to work. If at that point your job doesn't exist, you call me and we'll deal with it. Again, employmentlawyer.ca. Last question for the day from Jenny. My employer has not paid me for 3 months. What should I do? Have I been constructively dismissed? How do I get EI if I've been constructively dismissed? So yes, that's 100% a constructive dismissal. The most basic obligation that an employer has is to pay you on time. So yes, you're owed severance. And as part of getting that severance, we will get you a record of employment that allows you to apply for EI. You're not going to be able to do that on your own. We need to get involved. Yes, that's a constructive dismissal, Jenny. So I want you to connect with me as soon as possible through employmentlawyer.ca. It's not appropriate for you to be waiting all this time. Even if it was 3 weeks, it would be completely inappropriate. 3 months is ridiculous. Let's call it what it is, constructive dismissal, and get severance. All right, guys, thank you so much for being with me today. Hopefully I've answered all your questions. If I don't speak to you before, happy holidays. Otherwise, you can always connect with me through employmentlawyer.ca. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. This was the employment law session. Thank you again for joining me. All the best. We'll talk to you soon.